Welcome to our special Friday edition of the COVID immigration updates for employers and employees. We decided to have this special edition because of the new immigration regulations as it relates to F1 students, and there's been a lot of confusion and apprehension about this, these new imposed restrictions. For those of you who tried to join us Wednesday and couldn't join us for a technical glitch, this is also for you. So let's move forward with the updates, and I'm just going to share my PowerPoint. There we go. And let's give it a few minutes to get for people to join, and we'll get started. I know that, like I said, this is a very critical issue for most people, so we wanted to make sure that we covered everything. So let's get started. Here we go. So today, last week we had a lot of Q&A and answered a lot of questions. Today we're going to go over the F1 student restriction, the new restrictions that are in place, and then talk a little bit about what the legal challenges are. This has shaken not only the international student community, but the academic and business community or industries that support them as well. So there's been legal challenges. And finally, we're going to discuss the USCIS budget shortage and furloughs. Yay! If things could not get any worse, they have. So first, a brief recap of last week. We answered the immigration questions that people had, ranging from H-1B to, issues related to changing status, whether people should go ahead and continue to file for permanent residency. So a number of issues, even relating to L1s and terminations and so forth. So if you didn't get a chance to tune into that, you can do that by subscribing to our YouTube channel or taking a look at last week's episode on our YouTube. So first, let's discuss the temporary student restrictions. It was issued as a temporary final rule. Now, if you remember, just to give you some context, typically, the USCIS only allowed international students to take one online class. And so with the COVID issues and the vast pandemic, they made an exception in March. And they said, well, in certain instances, you can take all online classes. You can even have a reduction in your caseload if some of your online classes are not available online, like, for example, labs. So with that in place, it was issued as a temporary accommodation, if you will. So with everyone waiting bated breath to see what was going to be the rules for fall 2020, after Independence Day on July 6th, the USCIS issued the temporary final rule that suspended F1 students from taking full-time courses. So what does that entail? It entails, number one, that they won't issue visas for students enrolled in programs that are only online. And the Customs and Border Patrol, even if they have a visa and they try to enter, and they indicate that they're taking all online classes, they will not allow these students to then enter the United States. Active students that are currently enrolled in programs would have to depart the United States, or they would have to take measures such as transferring to a school that has the ability to take some in-person classes. And if they do not do that, they stated that they would initiate removal proceedings, which is pretty severe and serious. Now, as I stated, the F1 student rule is they can only take one online class at a time. And the accommodation that was made in March was an exception to, the rule. So they're reaffirming that they're going to, continue to adhere to that, so that students could only take a maximum 1 credit course online. Now, there is an exception, which is very interesting. It's called the hybrid model. The hybrid model is when there are certain classes that they're taking, that the students can take online, and certain classes that they have to take in person. So there is an in-person element to it. But what the hybrid model allows is it allows students to take more than one online class, assuming that the institution has some in-person classes. Now this all comes at a time where we're seeing the COVID pandemic really escalate. And we don't know what, the situation is going to be in the fall. And this is not even the second wave that they were talking about. This is still the first wave. And we're seeing that there are a lot of challenges in terms of safety. And so states that were, initially opening up their bars, restaurants for normal before COVID timeframe are now finding themselves in a situation where they're having to cut back and make additional restrictions. And because they found that, that has really led to the increase in, COVID cases in that state. So now universities and academic institutions, instead of, using the safety and welfare of their students as a primary objective, will have to then place this new rule, which says that their international students would have to depart if there's not a hybrid model. And we are seeing a lot of schools that are, I think UNC is going to have a hybrid model. There are other academic institutions that are looking at doing a hybrid model. But, unfortunately, the other thing is that the temporary new rule really didn't give the schools a lot of time to adjust to these changes. So schools that are entirely online will have to notify SVP no later than Wednesday, July 15th. They only instituted the rules July 6th, so that doesn't give them much time, because a lot of schools like, for example, MIT, Harvard, who had already committed to having a fully online curriculum, now have only a certain time period to kind of reassess what they're going to do. And the schools that will offer hybrid coursework, that is partially in person and partially online, will have until August 1st. And then by August 4th, the schools have to issue new I-20s to reflect that they're having all online classes. And they have to basically attest and say, the students are taking, they're not taking entirely online classes, and they're taking a mix of online and in-person classes. So it doesn't give the academic institutions much time to really grapple with this new rule and figure out what they need to do in the midst of dealing with this crazy pandemic. So, the time frame has really made it an additional challenge. They did release the FAQs. They said that the students who are enrolled in online classes through the summer are permitted to do that through the summer. They've also stated that students will be able to take online classes overseas. Like if it's a fully online course, they can depart and they would still be in the SVP system and SEVA system if they are taking online classes in their home country. They also said that for those who are enrolled, already paid their fees, and are not able to transfer to another institution, where they're no longer eligible to enroll in the fall because the academic institution in which they received the I-20 or they were admitted is taking all online classes, will not receive a refund for fees that were already paid. And finally, and this is the most troubling, that if the school decides to engage in a hybrid process, and you know, as a result, they are, I'm trying to see if there's any questions. Oops. As a result, they are in, you know, in mid-semester because the institution found that, you know, for health and safety reasons, they have to change to fully online, that these students would then have to depart, the international students. Or what they would have to do is they would have to make sure that they transfer to another institution that offers the hybrid, which is really troubling, to say the least. Okay, see, we have some questions. Hi, Lakshmi Garu. I'm answering some questions, you know, as I'm going through this. I'm glad they're questions. I always think, okay, did I screw something up technologically so that people couldn't answer questions? So this is good. Hi, Lakshmi Garu. My mom has a green card, but she will not be able to come by November due to pandemic situations. She left the US in February. How long can she stay in India without affecting her green card? Very good question. So I'm going to assume that your mom didn't have a reentry permit. So typically the rule is that if you depart the United States, permanent residence, and there are two issues here. Permanent residence for purposes of you know, citizenship. That means if eventually she's going to apply for citizenship, you can't stay out the United States for more than 6 months. And the reason is, for citizenship, there's a physical presence requirement. You have to be a permanent resident for, you know, a certain number of years, for 5 years. And within those 5 years, you have to be physically present in the United States for a certain period of time. I would say effectively about half. So if your mother is outside the United States for more than 6 months, that 5-year time period, that clock restarts. And then secondly, if becoming a US citizen is not an issue for your mother, then she is permitted to stay outside the United States for up to 1 year. Now, if a person has to stay outside the United States and they are pursuing citizenship and they have to get special permission, you can always, you know, talk to the Department of State consulate and try to get a special variance. But typically that's issued only if you intend to stay for greater than 1 year. What you could possibly do is if you are planning to file citizenship, when you do file for citizenship, for your mother, you can, assess whether you can file it and then put in the information that there was a travel ban, and it was not that she did not want to depart, but she was unable to depart. So there was extenuating circumstances that related to her inability to return to the United States. Somebody asked where our recent webinars will be on the YouTube page. They should be on the YouTube page by end of business today. Thank you for asking, and I'm glad that you're finding them helpful. So next, let's go to, like I said, it has been a tremendous challenge for not only academic institutions and the industry, because international talent is the biggest funnel to a lot of, the major Fortune 500 companies. And so, I had stated before that the US really benefits economically, and I wrote an article. So if you all have not subscribed to our immigration updates, I suggest that you do. And I said that President Trump's immigration restriction wall, the bricks that he's laying for this through immigration restrictions to effectively have his wall, is sitting right on top of economic growth, stifling our economy even more, our struggling economy, in fact. And international students contribute about, I think, $40 billion to the economy, hundreds of thousands of jobs as a result. They subsidize US tuition rates. And more importantly, it's not just the money, but they bring innovation right here to the United States so that the next Tesla or the next Moderna would be in the US. So it's really troubling on so many levels. And the US, since 2016, there's been a drop in international student rate, I think at almost 10%. So this is really going to really hurt the economy further and really stifle our ability to be the innovative center of the world. So people are up in arms. And so Harvard and MIT filed suit in the federal district court in Massachusetts, and the USC joined in. Now, how does that work? It's in a federal district court. So that means that if the federal district court enjoins the USCIS restriction, they can issue it statewide. So that means the USCIS would be precluded from enforcing it until it goes up the chain. In Hawaii versus Texas, Trump versus Hawaii, when the DACA issue was in place, the travel ban was in place, if you remember that soon after he took office, he instituted a travel ban for certain countries, and he had to have 3 iterations of that travel ban for it to finally be narrow enough that it was accepted by the court. So it went up the channel all the way up to the Supreme Court. And the Supreme Court affirmed President Trump's travel ban through an executive order. But there are a couple of things about that. Number one, they, when the Supreme Court said they would hear it, they released the injunction was no longer valid. So the ban was kept in place. Now this is the USCIS issuing a rule versus an executive order. So we had a YouTube that really dedicated to delving down deep in the distinction between the two, because whereas, you know, an executive order, the president's, you know, authority is only for the entry of, you know, non-immigrants into the United States, number one. Number two, the Supreme Court in Trump versus Hawaii stated that national security, that the president really didn't need to give details as his reasoning because it was a matter of national security. The recent restrictions that President Trump instituted with H's, L's, and J's are on the economy. So I wonder how that would be treated with the courts. Most of the time that there have been executive orders limiting immigration into the US, it has been because of national security. And because of the nature of national security, you don't want the United States government to have to defend itself in court and say, here are the things that we're worried about because of the secrecy and the security issues that are innate in something that's a national security matter. But if the matter is the economy, that's not confidential information. And that is something that they would effectively have to defend and kind of relate that the ban really effectuates the purpose that it purports. And so that'll be interesting to see from the executive order how that plays out. Here we have a USCIS rescinding their modification that they made in March. Now, one of the things that MIT and Harvard raises in their lawsuit is it didn't comport to the Administrative Procedures Act, which is notice and comment. We kind of talked about that before. I don't know if that in and of itself will be a strong enough argument because they're not implementing a new rule. They're withdrawing an exception. So it'll be interesting to see how that plays out. I know you have questions. I'm going to get to that as soon as I talk a little bit about the furloughs. Furloughs. So the USCIS request, it seems because of the drop in immigration filings since President Trump took office, the USCIS is under a major budget shortage. Now the USCIS, most people don't know this, is a self-funding agency. Most of their funds come from, you know, immigration filings. So they're receiving, they have a shortfall in the upwards of $1 billion. They're asking Congress, not for the full $1 billion, but for some money to keep it running. They also want to increase fees again by another 10%. So there's supposed to be some sort of bipartisan action on that. It hasn't taken place yet. If that doesn't happen in a timely manner, USCIS employees have already received notice that they may be furloughed. And you're talking about close to 13,000 employees. And with the USCIS backlog being as, you know, in record numbers, we're going to see an even larger backlog. Now, what we've noticed is, it's interesting, premium processing was implemented, as you know, in stages in June. So as soon as we upgrade one of our petitions to premium processing, we're getting a request for evidence immediately. Why? Because when a petition is filed premium processing, it's filed with a $1,440 fee, and it must be adjudicated within 15 days. Otherwise, the USCIS has to return the fee. The exception to that, however, is if the USCIS issues a request for evidence. Then they don't have to adhere to the 15-day rule. So we believe that they are doing that just to buy themselves more time if the case is processed premium. And it's evident by looking at the request for evidence that they're not even reading the petition. And we notice the dates. The date that they receive the upgrade for premium processing is the very date that they're issuing the request for evidence. So if you've upgraded to premium processing and you've received a request for evidence, don't be alarmed. That is just part and parcel of the process. Questions. So let's get to the questions. I have filed for a reinstatement, 9/11/2019. Receipt date, I get an update as additional documents were required. I have approved I-130, 11/14/2019. Planning to file for AOS. My question is, should I wait for the approval of the reinstatement, or should I wait for my spouse to get citizenship? Wow, okay. Here's the thing. You can only apply for AOS if you have an available visa number. So if you have an available visa number, then that works. You would be able to do that. If you don't have an available visa number, then you can't file for AOS, and your status you won't have any status. The other thing is, let me tell you what I think you should do, and I'll tell you why. You should try to get a reinstatement, notwithstanding what's going on with your AOS, because what's going to happen is if you file for adjustment of status, you have to be in a valid status to be able to file for adjustment of status. The exception to that is a US citizen. If your spouse is only eligible March of 2021, they have to file, it's got to get approved. That's going to take some time. And until it's approved, you won't be upgraded to being filed as a spouse of a US citizen. So a spouse of a US citizen, even if you're not in valid status, there's an argument to be made that you're still eligible for the benefit of adjustment of status. That's not the case for adjustment of status with a permanent resident. So I would go ahead and try to get the reinstatement put in place. So you would have kind of a nunc-pro-tunc on that means it would relate back to the time that there was a lapse in status, so that before you file your adjustment. I got a notice saying on July 2nd, we begin reviewing your I-130 for an alien relative. We mailed you your notice informing you of the action. We intend to take action of your case after I've sent an RFE in January. What does this mean? Depends on what the RFE was. They could have issuing you a notice is typically either they issued another RFE or it's a determination on your case. But it would depend on the nature of your RFE. If it's an I-130 petition, typically it relates to the birth certificates and things like that. So if you could tell me a little bit about what the nature of your RFE was, I can kind of help you with that a little bit. So email us at info@cellolaw.com with the nature of your RFE, and I can give you some insight, and you can tell me a little bit about what you submitted to see if, how the decision is going to pan out. Ma'am, I am on my F1 OPT. Are there any restrictions on the same? Would there be any kind of rules the government might potentially enforce? How would the H-1B process change post-November, post-COVID? Well, good question. So OPTs, if you are employed, there are no issues related to that because you're not engaging in full-time academic studies. So as long as you're employed, the F1 OPT should have no impact. Next year, a lot of that is going to depend on what's going to happen in November at the election. And I think at that point, we'd be able to assess what is going to happen. Because as you know, the restrictions that are in place for H-1Bs now, it's just to get a visa. So if someone's here and doesn't depart, the president's restrictions on H-1Bs are not impacted. So even if they're extended, he doesn't have the authority to ban H-1B filing totally going forward. So I think in that aspect, I won't say we're safe, but let's just pray that the election comes out in a manner that's favorable to the immigration population. What could be this motive by SEVIS? Well, the motive's not by SEVIS. The motive, okay, it's, you know, it's interesting you ask that because, you know, on the same front, the administration is what drives the USCIS or the Department of Homeland Security. Department of Homeland Security is what dictates to SEVIS what the process should be. Now, if you've been paying attention to the news, the president is also really pushing for even elementary schools to open up. And so on one hand, they've been trying to enforce their restrictions, immigration restrictions to impact immigration. So that's one thing. So it could be related to that. But number two, they really believe that if schools are, you know, elementary schools and schools of higher education can, you know, go back to functionally a normal in-person process, that could help the economy. Because think about it, when kids go back to school, you'll have to buy school supplies, the buses will run, you'll have to have the janitors, there's a whole, you know, indirect, it's not just the professors who are still, the teachers and professors are still getting paid, but it's the, you know, the supporting, you know, the indirect and sometimes supporting industries that they think will help increase the economy. So it could be either or it could be both, you know, kill two birds with one stone, if you will. Thank you for answering. What's the procedure to get special permission for my mom to stay overseas? From the USCIS, once a person is outside the United States, the USCIS really no longer has jurisdiction. So it would be the consulates and Department of State, and they're not opening yet. They think they'll open by September, October. So, and I think it'll also depend on the country conditions. Usually the special permission is for a person that has to stay greater than 1 year. So I don't know if they would grant it for 6 months for purposes of preserving your mom's ability to file for citizenship. But I think at least if you can get an appointment and try, you know, you would be able to explain that. If you're not able to get an appointment and they will not attempt to review, you know, your mother's situation, when you file for citizenship on your N-400, what you can do is kind of clearly outline that it was a travel ban. So any evidence that you have now that the airline is not running, that the country is not allowing departures. I know India is allowing some departures. I know that you have to apply and there's a lottery and there are special planes that are coming back. So they would also probably want to see that you've done that and have not been successful. So those are the type of evidence I would pull together so you can file your N-400 in case Department of State will not entertain giving a variance to your mother. Thanks for the session. You're welcome. I have an I-140 approved with a previous employer. They withdrew my petition after 180 days. Nepal is the place of birth. Am I still eligible for filing a 485 green card processing? I am currently on 60-day grace period because my H-1B job was impacted because of COVID. Okay. So you're talking about the portability of your green card, where the portability of green card says that if your I-140 was approved and your adjustment of status was pending for 180 days, you can change employers, provided you're working in same or similar employment. So you indicated that you're currently unemployed. You would have to show that you are employed in same and similar employment when you have your adjustment interview. And there's a special form now that you've got to update the USCIS. So you are eligible for filing a 485, but you should be willing to demonstrate that you're working in same or similar employment. Now, they really don't have a wage requirement for that. It's just same and similar employment. So I think that may help you, but for your H-1B purposes, you would need to have a wage. So, there are strategic ways to think about that. Now, if you file for your 485 without having your having a valid H-1B, the critical issue would be that if the adjustment's denied and you don't have a valid status, they're issuing RFEs on that very issue. So I would try to get a new employer on your H-1B and file for an amendment of status and then file for the adjustment. That's what I would do if I were you. And that would be, I think, the safest bet going forward. Hi, I'm on a green card application, is on hold, or can we apply this year? Yeah, Richa, as long as you're not applying, the only applications that are on hold are those that are applying overseas. If you're here in the United States, you can still apply for adjustment of status. So that's not a problem. So if you're here, there is no ban or restriction on permanent resident processing. What should one do to some circumstances? B2 was filed a few days after the 60th day of the last day I worked on the H-1B layoff. Should I wait for a B2 decision or leave before 180 days from the last day worked? Can H-1B filed if an employer is willing to file in the meantime? Well, your 60 days are over, and we had discussed previously that there's a difference between lawful status and there's a difference between a status authorized by the Attorney General. Now, if you filed after your 60 days, the 60-day period is a status authorized by the Attorney General. It's a grace period. You're not in any particular status at the time because you're no longer employed as an H-1B. But you're in a grace period, so it's a status authorized. You can change status or extend status to anything within that grace period. Once that grace period expires, you're no longer in an authorized status. So your change of status will not be adjudicated favorably. I would depart before 180 days because you are accruing unlawful presence. So you should depart the United States. I am planning to file an H-4 EAD. Do I need to be employed to file the I-485? What was the basis of your I-485? Because as I just stated a second ago, if it was an employment-based I-485, and you were the one being sponsored, then yes, you need to be employed. But if your spouse, if you're filing an I-45 based on your spouse's employment and you're just the beneficiary, then no, you don't need to be employed. So that's not a problem. What should I do? I think I answered that. And then, yeah, it's employment based. I don't know what that, anonymous attendee, can you, because I've had a couple of anonymous attendees ask questions. So if you can give me a little more details, that would be great. With the proclamation, online classes, students need to go back to India, their respective country. As an employer, would you advise on hiring anyone on CPT? Good question. I would remember that the schools have to do new reporting, and so a new I-20 would have to be issued by August 4th, indicating that it's a hybrid school. So if you want to ensure that, as an employer, when you hire anyone, you have to go through the I-9 process. One of the I-9 documents that a CPT would have to present to you is an I-20. So as long as you see that the I-20 is endorsed with the language that I had outlined earlier, that it's a hybrid institution, that will let you know whether the student is currently on valid status. Because if they're not on valid status, then there could be some problems for you. Let me see. I want to make sure that all the questions are. Okay. I think there's another question that's come up. You're welcome. You're welcome. And just to remind everyone, we are now hosting these webinars every Wednesday. So I changed it from Monday because, a lot of times the news, we have new news that's coming up on Monday, and then I would have missed it if we had the seminar Monday morning. So we're changing it to Wednesday, which gives us more time to address any of the latest updates that have come up. If there are certain topics you want me to cover, like portability, permanent residence, other issues, please let me know. Oh, there's another question. I am planning to file an H-4 EAD okay. If both, this is a question from the individual who's on an H-4 EAD, and they had asked whether they needed to be employed to file the I-485. Now they clarify and say that my spouse and myself both have an I-140 approved. Both of our I-140s in employment-based filings. Well, so whoever is the primary on the I-140 that's going to be supporting your 485 filing, that person has to be employed. So if it's your spouse's I-140 that you're basing the I-485 filing, then you've got to demonstrate that your spouse is employed. As an H-4 EAD, you don't need to be employed. If, on the other hand, you're filing the I-140 based on, you're filing the 485 based on your I-140, then you have to demonstrate you are in same or similar employment and that you're eligible for the portability provision that's outlined. I hope that helps. I would be interested for next Wednesday how to handle, even after a third attempt, an OPT is not picked up for the H-1B lottery. Yeah. Oh, no, that's a good point. I will make sure to address. We have done that in the past, but certainly can talk about any new options for H-1Bs that are not picked up in the lottery. I'm sorry that you didn't get it even on the third bend. Hopefully next time, you know, you'll be luckier, but Vijay, I will address that next week, next Wednesday. Thank you. I filed a change of status for an H-1B to B2 on April 2nd. Do I have to wait for it to be approved before I can file a change of status back from B2 to H-1B in premium processing? You know, they call that bridging. You know, you can, if you're still within your grace period, then you'd have an argument that you have filed while you're in your grace period. If you're not in your grace period, you can file it. I don't think that they will adjudicate it until the B2's adjudicated, which is what they've done in the past. But if you are still within your 60-day grace period, I think you've got an argument to at least say, you know, I'm in a status authorized, so, you know, I am eligible, independently of my change of status. The problem is with the change of status, if you're filed for a change of status and you've already expired, your authorized status is dependent on that particular change of status petition. So they won't adjudicate anything else until that's approved. Do you see the difference between the two? So if you are in a, you know, in an authorized status, then you could go ahead and do that. Please comment and subscribe to our YouTube video. We will make sure to upload the latest videos today, as well as a couple of others. We use different mechanisms of social media to communicate different messages. So make sure you follow us on social media. And if there's any questions you couldn't answer today or we couldn't get to today, you know, please email me at info@challalaw.com. We know that a lot of people are really stressed out and you're trying to figure out what the options are. As you can see, I'm giving you answers. I'm not saying, and even the people that email me at info@challalaw, I have not to this point said, oh, I need to charge you a consultation fee. I'm doing this because I want to help you. So if you could forward this to your contact groups so we can get the message out, I would really appreciate that so that we can help as many people as possible. I'm committing to answering all the info emails, and we're getting quite a few of them. So I'm not able to do it immediately. I do a bulk a day, but I will get to whatever question you have asked. And thank you again. If there's anything that you would like us to address, like I said before, or any other way you think we could be more helpful to the community, we would be happy to do that. We're going to try to put together a forum for, you know, in conjunction with this, where people can talk and there can be a great discussion. And it's not driven by where I've seen the other forums are driven by, you know, trying to get people like myself to actually pay them money to give the people in the forum and discussion some real legal advice and information or resources. This would be primarily just to make sure that we have a safe place where people can ask questions and, you know, really get answers and get resources so they can navigate through the challenges and achieve their immigration objective. So thank you again for listening in. I think there's another question. And I think we can take one last one before we finish. Thank you, and Lakshmi and that both of you are doing great work. Well, thank you. I am glad this has been helpful. That is our objective. We want to make sure that we can do whatever we can to help everyone out when we're in crisis mode, right? So join me again next Wednesday. I look forward to hearing from you. Subscribe, share our information with your contacts so we can help as many people as possible, and we'll keep you posted on the forum. And I hope you guys have a wonderful weekend. Safe, socially, I won't say socially distant, physically distant, but socially close weekend. Thanks again. Bye-bye. Oh, is there another question? There is another question on chat. In case somebody was planning for an L1 transfer for his own business, what is the best time to start the application? We've been telling people to go ahead and get started with that because it takes some time. So you can come on a B1, and there's a lot of things you can do on a B1 in preparation for your L. You can set up an entity, you can set up a bank account, you can find office space, you can make sure that your sales pool is in place for you to file. And you can still file the L1. You just can't get a visa until December 30th or until there's a change in that particular executive order. And then the other thing is, if you are from an E2 country, you're eligible to come on the E2. But you can do a vast majority of things that you need to do to set up your investment and transfer into the United States on the B1 and file for the L1 and, process 2021. And hopefully, like I said, November we'll have a new administration. And even if we don't, perhaps the president will back off on extending this ban, because understanding that it's actually investing foreign direct investment into the United States. And who doesn't want to grow the economy with somebody else's money, right? So that's what my advice to you would be for the L1. I hope that helps. So again, I'm going to say goodbye. If I haven't had a chance to answer your question, please email us at info@cellalaw.com. Again, have a safe weekend. Look forward to talking to you next week. Take care.